time. Your session was extremely good. And this is a very important topic that you're going to address. So it will be very helpful for everyone. Please go ahead.
Thank you very much, Aparna ma'am. So participants, again, Narmada ma'am will be taking us through the session, and then end of the session, we can have the question answer round if time permits. You can raise your hands, or you can just send a message in the chat box. The chat box option is enabled, so you can send a message for your question, your questions, and then we can put forward it to Narmada ma'am. So thank you once again. Narmada ma'am, over to you, ma'am. You can start.
Good morning, all. Hoping to find you all in pink health. And Madras Tax Bar. It's amazing to note that you all have completed 50 webinars. A special thanks to AP Srinivas, Prithvi, and Aparna, keeping all our dopamine in high spirit. In fact, it's good during lockdown, instead of just to be static, we are all kept on toes by reading and then interacting and knowing the other branch of law. It's a good endeavor. And today's topic, Article 21. Now, the Constitution, it's a very important document as far as our country is concerned. And the intrinsic intelligence, the emotional life, and the heightening sensation of our people made a cry for independence. In fact, it all started at the Battle of Bengal way back. And the one and only demand was that they wanted liberty, independence, freedom. So which led to in fact, the demand was to have a codified document, a written document, all for themselves. And that document to be a document which is from the seeds grown here and self-grown. So they're very clear about what were their needs. So every norm and every value of individual, as far as our country was concerned, was taken note of. Justice Kanya, at the time of inaugurating the Supreme Court, he quoted stating that the Constitution is emblem of God. So that much of value, it was given to the document. When the Constituent Assembly was given the job of drafting our Constitution, there was a lot of deliberations, discussions. Dr. Ambedkar, being the chairman of the Constituent Assembly, he did say, this document has got a soul, a heart, and no doubt till today it has just catered all our needs. And with today's date, 22nd of May 2020, we have seen about 103 amendments so far, but still we are going so steady, and it is matching the needs of every citizen. Now I'm going to take you all to the little history of American law, and thereafter I'm going to come to our Indian law, and then this enshrined principle of Article 21, how the scope of it has enhanced. This is going to be my endeavor today. Now, the preamble, as you all know, it has the republic, democracy, and sovereignty. It talks about these three basic principles. And these three basic principles does not only cover those aspects alone. The preamble also covers the expression of thoughts, freedom of thoughts, faith, belief, and so on and so forth. Now, preamble has to be read along with Constitution. This is the judgment rendered in the famous judgment of Holiness of Keshavananda Bharati. You all must be aware of it. And regarding the expansion of the scope of Article 21, as you all know, the ultimate authority to interpret any provision in the Constitution is the Honorable Supreme Court, no doubt about it. For expanding or for expounding the scope of Article 21, the Honorable Supreme Court has laid its experience to American law. Now, talking about American law, I need to cover little history. As I was just telling you, here also we had a cry for independence and liberty and freedom. Likewise, I'm going to talk about the actual cry which was echoing in the land of United States way back. I'm going to refer about 3 cases. The first being the case of Dred Scott. It's a very famous case. It's of the year 1857. Dred Scott was a slave, and his master moved to a state called, a brief facts I'm just going to narrate. He moved to a place called Missouri. Those days it used to be a very big state. And Missouri was actually having other states within itself. This is only to note that they had different local laws. So when Dred Scott was taken to one particular state in Missouri, there they never had this system of slavery. You know, slavery where the cry was for nutrition, good clothing, and freedom to move. This was the basic cry. So when Dred Scott went there, he actually fell in love with another non-white, and then he got married, and the master had to move from Missouri to Minnesota. So when they moved to Minnesota, which is the land of lakes, and there his wife was expecting a child, and the master had to move to another state. Then Dred Scott just denied, stating that, look, I have been taken to Missouri, that too to a state which abolishes the slavery system. Therefore, I'm free, and I'm no more a commodity, because they were sold like a commodity. They were taken wherever the masters used to take wherever they want these slaves along with them. So since his wife was expecting, he kind of resisted, stating that I don't want to join. Then that was denied by the master. Then the matter went up to the Supreme Court. This is the most infamous judgment in the history of America, where the judge Taney stated that the citizenship, that is, the citizens alone are entitled to tap the doors of judiciary of the Supreme Court, but not the others. So they were all treated to be the second-class citizens. So thereafter, the law remained the same. As you all know, the Plessy case is also like where our gentleman Plessy, accidentally he got into the coach which was meant for whites. And then he was charge sheeted, stating that he had encroached on the other coach. And then he filed a case stating that, look, I have a valid ticket, I have a valid pass to, I have paid, and I have every right. And this is like infringing on my 5th Amendment and 14th Amendment. I can move with them. Why are you saying I can't go in the same coach? Then the Supreme Court said, yes, we agree. You're right. You're equal, but separate. This was the judgment rendered in Plessy. Thereafter, this judgment was actually held to be a bad law in the next judgment of Brown versus Board of Education. There again, the brief facts are, the classrooms were separate for both whites and non-whites. So then the Supreme Court said, no question of you having separate classrooms. It should be uniform for everybody. So no question of any discrimination. And that's how they turned down. In fact, they nullified the judgment of Plessy. And they said this is squarely in violation of their Amendment 4 and Amendment 14. Amendment 4, 5, and 14. Now coming to the concepts to render those verdicts. The American court had 2 basic concepts. The first one is Daisy theory, and the second one is Blackstone theory. These theories are of some significance. That is, what is right to life? What is right to personal liberty? According to the Daisy theory, a personal liberty is the liberty of an individual to expect that he can't be arrested, he can't be detained, he can't be imprisoned without due process. That is, the due process should satisfy the justicious mechanism. Likewise, Blackstone theory, it talks about the power of locomotion, to the will of the person who is being moved. He can move wherever he wants, but his movement can never be restrained unless you establish the due process has been invoked to restrain him. If you just see, these two theories are actually a different form, but the contents are the same, the substance are the same. Down the line, no person is deprived of their life and personal liberty without due process. So the right to life did not stop only with that. Right to life actually got expounded. It is due to the inner intellect, inner viability, and the jurisprudential approach towards a problem has made it possible for having a expanded scope of a development in terms of right to life and personal liberty. The very famous case which actually expounded it to the concept, the first case is the case of Mann versus Illinois. It is of the year 1876. And the facts of the case are that a person, I mean, it is relating to farmers and their fixation of the charges by the warehouse holders, and then that those are the facts. But in a dissent judgment by Justice Field, he had stated the right to life is not just a mere animal existence. It is something more. So here, the first concept, that is, you can't treat a person just that he's having a life and he has a liberty. No. He has to be treated more and above. There is something more. There is a meaning in his life. He can't be treated like an animal. So this was the first reflection, the concept of expounding the right to life, because they have only right to life, right to liberty and property. So that is the Fifth Amendment. The intervention of the court to give a meaning to that concept was for the first time in Mann versus Illinois. Then the second, in fact, there two facets, in fact, that is of some significance to note. The first one is regarding the Fifth Amendment. What they said was, there are limitations to the power, even when you are invoking your due process to infringe on somebody's right to life or personal liberty. The limitation is there with the authorities. And if there is a breach of limitation, they invoke Amendment 14 to state that you will be compensated. So they knew what the rights were available for them. The next most celebrated judgment was Wolf versus Colorado. This Wolf was a doctor, and the main charge against him was that he had conducted many medical procedures without the knowledge of the government. So there was a seizure which led to obtaining of evidences against him, and he was charge sheeted. There again, Dr. Wolf, he kind of like put forth 2 points before the Honorable Supreme Court. The first one was, now I'll just refer about the amendments. As far as today's topic is concerned, we'll be only touching on the Fourth Amendment, Fifth Amendment, and Sixth Amendment. Fourth Amendment is stating that everybody's right is there. It's available as far as American citizens are concerned regarding an illegal search, an illegal seizure. That is the Fourth Amendment. Fifth Amendment talks about there is a right to remain silent and also right to due process. And the Fifth Amendment, the third facet would be the right to compensation if your land is taken away. Now I'll take you all to each facets in an individual manner. But let me just complete. Fourth, Fifth, and Sixth Amendment talks about the person is entitled for an attorney, person is entitled for a jury, the person is entitled to bring in a witness, and so on. So the first, which I was just referring about, the Fourth Amendment, it talks about the right to an illegal search. So in Wolf's case, the main contention was that he has the right to live or to lead a life with peace. And nobody can just walk into his house without a warrant and state that I'm going to search and I'm going to seize these materials. So he said that is squarely infringing the right under Amendment 4. This was his case. And secondly, his point was the material which was obtained behind my back can never be utilized in the court of law, was the second plea. And to the surprise, both pleas were accepted. They said, you can't, without a warrant, how can you even enter into somebody's house and seize a material or an evidence? And how can you place those evidences against him? So that is under Fifth Amendment. And then the sixth would be like, he can state that there is also a right to remain silent. That is, you can't be forced to or to state or to accept or to confess. So by and large, if you just see the expansion of expounding nature of right to life and right to liberty as far as America was concerned, all started there, those two judgments. That is, they brought in the concept to understand that you can't have any procedure which is directly violating their rights. Now, coming to our country, the first judgment would be the judgment which was rendered in, it's a state of UP case, Correct Singh. As you all know, that was a judgment for the first time where they read Article 21 along with, in fact, that's a dissenting judgment where they read Article 21 along with 19. But the majority judgment, which was rendered by Rajagopal Iyengar, where I'll just narrate brief facts about that case. Here, the Correct Singh was a history sheeter. There was a history sheet against him, and the charge against him was that he was involved in dacoits, and there were many cases which were pending against him. So every now and then there was surveillance, and there the regulation of UP police regulation permitted, that is regulation 236 allowed for such a surveillance. So the main contention of Correct Singh was that I have every right under Article 21. I'm enjoying a right to freedom, right to life and personal liberty, and they can't be all the time infringing on that by having a surveillance midnight, waking me up, and I'm not even allowed to move, because now directly he attacked the said said regulation on the score, stating that it's infringing on Article 19. He wanted 19 to be read along with 21. 19, as you all know, 19(1)(d) was his main contention, but 19, by and large, it talks about freedom of speech, and then association without arms, then association to start any association, then you can move to any place within the territory of our country. You have freedom, and the freedom of property, which was dispensed with later, and then the last would be the freedom of to establish business. So these rights, according to him, he wanted squarely 19(1) to be read along with Article 21. The majority judgment actually accepted his plea as far as one aspect was concerned. They said Article 21, yes, if they want to infringe on Article 21, the burden is on the government to prove that they have followed the procedure established by law without any deviation. So that was the majority judgment. But the dissent judgment, where it was held that the 21 cannot be isolated. You can't put it in an isolated pocket. It is something to be read along with 19, because it is all kind of like intrinsic value which has been identified by our constitution. This was the dissent judgment. Now I'll take, there is a link between the dissent also, which became the law later. Regarding the next most famous case, because here if you just see, as far as our country is concerned, the jurisprudential approach towards the problem, it was not static that they stuck to the enshrined principles of the Constitution. It was just actually addressing the real need, the real cry of the citizens, and it was adopting. It was like, because we have even got into the aspect of dignity as a right to life and right to private personal liberty. So to that level, it has gone. The right to dignity has been now considered as constitutional value. So that much they have kind of expounded this, because they always saw the right to life and personal liberty to be a road. It's a map of road which is taking you to various other rights. It is just kind of eliminating that what are all available. In fact, if you just talk about right to life, it is not this right to life alone with personal liberty, but now today the aspect has gone to the level of quoting that we have right to education, that is Article 21A, and right against exploitation, right against violence, right against inequality. So we have so much. It has just grown. It is outgrown. It is just kind of catering the real need and the cry of the society, because they were very sure every value and every norm had to be taken note of, and that has been like well appreciated by our jurisprudential approach. And all these judgments will actually, it is so heartening and it is so fascinating to note that how much we have walked with all these 103 amendments. Still we have just come so steady. Now, regarding the personal liberty, is it that can we just confine only to these basic rights? No. Personal liberty is where you can expect something more. You can expect right to environment, good environment, right to good shelter, good clothing, and right to pollution free. That even environment will cover that. And also the order, that is bad order. You can, if you have a right, when you're exposed to sewage, you can just make a complaint stating that it's infringing our right of life or personal liberty. And also we can also understand that the right to life and personal liberty is gone to the extent of stating that we can even say no to a sound. That is, we have that right to noise and vibration. So it goes on. The scope of Article 21 has expounded, and the courts have always come to the rescue and they have responded. That's really amazing. And in fact, it should be, it has just taken so much time to understand. It is not just an insulated concept, but it has a life which has taken care of, is the main endeavor of me to put forth before you all today. Then the next famous case would be Maneka Gandhi. Maneka Gandhi, I won't touch much on the facts, only regarding the difference. The correct thing, what they said was, you can't read Article 21 along with 19 was the majority decision, but whereas the minority stated 19(1)(d) or 19 for that matter can be read along with 21. That was approved in Maneka Gandhi. In Maneka Gandhi, not only 19 and 21, even 14, because her passport was impounded. So that's the case where she had to go to another country for attending a seminar. In fact, she had to address a conference where they invoked the Passport Act and they had impounded, where she had challenged it, where for the first time the court had actually read 14, 19 and 21 together to state that a person cannot be deprived of the rights unless they establish that the rules are followed scrupulously without any deviation. Now, coming to one judgment regarding other aspect. This aspect is actually very, very important to note. The concept of that judgment was that the right to life and right to personal liberty is an inborn right. That is, it's an inherited or inherent power within ourselves. And the constitution has only acknowledged the fact. So for anyone to deny, that was during the emergency time, 1976, the case was relating to the suspension of Article 21. And in turn, they said no cases can be, that's a presidential order stating that they can't file a petition under 32, stating that Article 21 has been suspended. So the court said, in majority opinion, that Article 21, that the right is available, but when there is the other circumstances need, I'm not going into the majority opinion because they said the other circumstances also needs to be taken note of. And the dissent is very important in that, which later became the law. In the dissent judgment, Justice Khanna stated that, look, you don't consider Article 21 as a right given by the constitution to an individual. It is a right which is born with. Only thing is we have recognized it later. So you can't deny Article 21 stating that he doesn't have such a power for right to life or right to personal liberty. So that became later the law. That is Jabalpur, which I don't want. It was considered to be an infamous judgment. But that was accepted later in Puttaswamy. You all know other case. Now, a very famous saying by Mr. Nani Palkiwala, he had stated that the liberty is something which the people they have given to the authorities and to the government. And it is not the authorities or the government in turn has given liberty to us. So the concept is that we have chosen somebody whom we want, and they have to ensure that every right of us is taken care. It is, in fact, now one more aspect which I have to cover is regarding privacy. Privacy, it can go along with human dignity. The human dignity has been, it's actually, if you just look at Constitution, Article 21 does not talk about dignity or privacy. But how is that has been now made as our law? I can take you all to the old judgment of Douglas, where Justice Douglas stated that the human dignity is the penumbra of right to life and liberty. That is, it's there within these aspects. It's not that you need to have a different concept or an article for it. It is to ensure that every human being lives to that is the satisfaction of living. He needs to have a feeling that he has the utmost fulfillment in attaining whatever he wants. That is, the thoughts he should be allowed to think, he should be allowed to read, he should be allowed to express what he wants. So that is the human dignity. And that value is now considered to be a constitutional value. Now, taking note of other aspects regarding when I talk about the dignity or the constitutional value, I also need to note, I also need to make, I need to address few other aspects regarding the environment first. Environment, when you talk about environment, very famous case which went from our state of Tamil Nadu, Vellore case. This is relating to tannery. You all know in and around Vellore, the tannery business happens, and every day, every now and then, so much of water is being consumed for processing the products. With the result, the water got polluted and cattle was drinking, people were drinking, and they all were falling sick. So the court brought in the concept of polluter pays for the first time, stating that if you are going to pollute, please make the payment. And also, it didn't stop with that. another one famous case relating to the environment. In fact, Kerala is a standing example in recent past. The floods which has happened because the tree shade has completely gone. Deforestation has happened where in fact, it was such a big devastating natural disaster which happened. And the concept here is whatever we are now enjoying in terms of environment is something which we have got from our forefathers. So we have a commitment. We have a commitment to give the same as it is, or in a better way, to our generation, to our children, to our grandchildren. It is actually a commitment. It is an intergeneration commitment which we have. It is within us to ensure that we protect the environment and we give it, or we take it forward for our generations to enjoy intact. Then right to health is also a very important topic regarding the how right to health has been read along with Article 21. Three famous cases. The first one was relating to a farmer from West Bengal when he had a fall from a train. He was taken to a hospital in the first place. There they had denied him an entry, and thereafter, because they had they assumed that to be a more critical case, and then they had sent him to another hospital which had more facilities. With the result, he had lost his life. So the court intervened, and then they stated that you can't deny a person's admission in the hospital. That is also a right which is now being found under Article 21. And in right to health, the second famous judgment would be the motor accident claims. You all know in motor accident cases where the hospitals generally they insist on the formalities, basic formalities of expecting a registration of FIR and then so on. So and the court had intervened and stated that you can't be expecting all those formalities to be complied in the first place. Please ensure that the person is given treatment, and thereafter, because life is something you can't lose a life on these formalities or basic requirements. Then the third judgment on health would be the latest judgment of the Honorable Supreme Court regarding the bonds which are executed by the students who are doing medicine. There, at the time of joining the courses, they execute a bond stating that they'll serve the government hospitals and primary health centers. And then once when they complete, the idea is that the public money is being spent on them because it's a subsidized fee which the government is collecting from them. So to ensure that the amount which is being spent on these people should be actually benefiting the general public in turn. So the bonds were obtained and there was infringement of those conditions, and which was struck down by the court stating that because the doctors, they said the bonds are actually violating the contract, basic contract, and they can finish their higher education and come back. The court said, no, nothing doing. You have, with eyes wide open, you have subjected yourself to the terms and conditions, and you need to honor the commitment because the general public is being benefited. So there again, the concept of right to health was recognized. And another one, another important facet in this Article 21, which has just been the brainchild of our Honorable Court, is Vishaka. That is the sexual harassment at workplace. We being the signatory to various conventions, even though we never had a law at that point of time, the Honorable Supreme Court stated that we need to have committees wherein the women should be treated well, and they should have a forum to express their concerns or the problems or so on and so forth. Now there is a law, there is an act as far as right to sexual harassment. Now I think with this I should conclude, and we have just seen the walk of how the scope of Article 21 has got expounded by the jurisprudential approach or intellectual approach by the courts. So thank you all.